No, yeah.
Okay, great. Good morning, everyone. I thought I'd have a beach background this morning to brighten everyone's day up. And just hopeful wishes that I was on a beach somewhere, I guess. Anyway, yeah, I'm Chris Boyle, Head of Employment at Napthens Employment Team. This is a Q&A session on employment law and coronavirus issues. I think everyone will appreciate that since we did the session last week, things have moved on at a pace. A week is a long time in employment law, as we seem to see these days. And I just want to run through some of the changes that we've got, and then obviously people can ask questions. Just a bit of housekeeping, as I said last week, if anyone does have a question, please put question in capital letters in the chat box so that we can pick those people in turn. So Hirin will pick those people in turn. So question, capital letters in the chat box. We have had a few questions through in advance and we will prioritize those questions. So just in terms of the last week, so if we scroll back to last Friday, we got the third rendition of the guidance for the coronavirus job retention scheme. And that introduced some of the things that we thought would come in any event. So we got confirmation that TUPE staff can qualify and be furloughed or eligible to be furloughed. We got confirmation that an employee or an employer can switch employees who are on sick leave and furlough. In that period, they can switch them on and off from furlough to sick leave. And we got the much awaited confirmation that employees who are shielding, so the extremely vulnerable category of society who have been listened to by the government, can shield. And that was amended. If you remember, there was a caveat that those employees could only be furloughed if there was otherwise a redundancy situation. So that was taken out to just leave anyone who was shielding could be furloughed. And there was some small clarification around NI and pension elements being on the furloughed salary as opposed to the main salary. Then obviously, as things progressed over the last few days, the start of this week, we then received confirmation that the government had dealt with this issue, which had been spoken about since furlough came in, that people were being disadvantaged if they were employed after the 28th of February and therefore didn't qualify for the scheme, bearing in mind the scheme came in on the 20th. So they've now changed that qualifying date to the 19th of March. And I'm guessing there's going to be some questions on this, but the provisions now say that the employees must have been on the PAYE payroll on or before the 19th of March 2020, and which were notified to HMRC on the RTI submission on or before 19th of March 2020. RTI being the real-time information which is sent to HMRC when the individual is effectively paid. So that came in this week. Along with that, obviously, came this direction from the Treasury, which came out alongside the additional guidance, which has introduced obviously this 19th of March point. It's clarified now that the scheme is not necessarily for those employees who would otherwise have been made redundant. It applies to any employees who may be furloughed by reason of circumstances as a result of coronavirus disease. And that's the terminology within the direction from the Treasury. It sought to clarify issues around what a director can do, so they can effectively fulfil their direct and statutory duties arising from an act of Parliament. So that's quite a narrow definition. And importantly, the guidance and then the direction from the Treasury confirmed that any agreements furlough must be in writing between the employer and the employee. So previously this hadn't been said, it just said there had to be an agreement between the parties. Now it has to be in writing, and obviously a lot of employers have done that in any event, but it is an important change that in terms of furlough being effective. In the direction, there has been an additional point raised which will need some clarification, but if you read the direction, you'll see that there's reference in there that an employer cannot claim for any salary which is conditional on any matter. So it isn't clear what that reference actually means, because payments, wages, commission, for example, are all effectively conditional upon something. So we need some further clarity on that point, and we're hoping to get some clarity on that point soon. And then, apart from those changes, last night we then got some additional legislation, which you may have seen or you may not have seen, from the government, which, and I'll just show you quickly now. So these are the changes to the statutory sick pay regulations. So you'll recall that the statutory sick pay regulations were amended to cover employees who were self-isolating. There was some discussion as to whether they were going to be changed to cover shielding, employees who were shielding. That didn't come. So I've got the right one now, actually. Yeah, so that didn't come initially, but now, as of last night, we now have confirmation that employees who are shielding or who fall under the extremely vulnerable category do qualify for sick pay. Okay, those are the points. I'm sure you're all aware of those, so I'm now happy to start taking some questions. So, Hywyn, who have we got for the first question, please?
We have Maureen Whitaker. I'm just gonna unmute her now. Give me 2 seconds.
Thank you.
Yeah,
Good morning again, Chris.
Oh, hi, Maureen. How are you doing?
Okay, thank you. You've touched on it briefly, the point about the qualifying date being changed. Yes. We had to let go 2 members of staff because they were employed after the original qualifying date. One has since returned to a part-time job he once had. The other is still without employment, of course. So, yeah. Where do we stand on either of those?
When did you employ them? What date did you employ them?
It was about the 28th of February.
Right, so the guidance says that employees that were employed as of the 28th of February on pay. Sorry,
it was the beginning of March. It was just a couple of days that they missed out.
Yeah, they won't qualify, unfortunately. They've got to be employed. The provisions around rehiring employees it's still relevant. The 28th of February date is still relevant. So they have to be on the payrolls the 28th of February. They've got to be notified to HMRC on our RTI submission before the 28th of February in order to then re-employ them. They can be rehired. If we satisfy those conditions, they can be rehired even after the 19th of March. But if for employees that were hired 1st, 2nd of March, they fall within this gap, unfortunately, where you couldn't rehire them. But if their RTI, if they have a job with their new employer and they're on payroll and their RTI has been submitted, then they will qualify for furlough on that. For their new employer.
Because I'm not fully au fait with the RTI submission, that would be our finance people. So can you just clarify that for me again? They have to have been submitted.
Yeah, so it's probably helpful if I pull up the guidance, close that down, move you along. So if we pull up the guidance here, you'll see, so here, employees you will claim for, and it goes on about 19th of March and on or before 19th of March, which were notified to HMRC on our RTI submission. And you see the last paragraph, employees that were employed as of the 28th of February 2020 and on payroll, i.e. that they were notified to HMRC on an RTI submission. So that generally means, with my understanding of payroll, is that is a submission which is made effectively when the employee is about to be paid to HMRC. So if they hit that criteria, and they were made redundant or stopped working for the employer after that date, but prior to 9th of March, then they can effectively qualify. And if we go down here, if you made employees redundant or they stopped working for you on or after the 28th of February, you can re-employ them, put them on furlough and claim for their wages through the scheme. This applies to employees that were made redundant or stopped working for you after the 28th of February, even if you do not re-employ them until after the 19th of March. This applies as long as the employee was on your payroll as at the 28th of February and had been notified to HMRC on an RTI submission. So you can re-employ people, but they have to hit this criteria here of being on the payroll as of 28th of Feb. Does that make sense?
I'll go to the government website and copy and paste that then. Right.
So that's always a good option. Always a good option. Okay, that's great.
Yeah. Thank you, Chris.
Thank you very much. Thanks, Ryan. Cheers. Okay, Ian.
Okay, we're gonna go through those 3 questions came through first.
Okay, that's great.
We need to cover them.
Thank you.
Just give me 2 seconds. I'm gonna put Paul on mute now.
All right. Good morning, everybody.
Hi, morning. How you doing?
Chris, you've maybe answered this, but I do apologise if I've missed missed the point on this one. A member of my team has been on she's on long-term sick at the moment, and before the coronavirus, obviously. So I was just wondering, she's coming to the end of a company sick pay now, and she's just going on statutory sick pay.
Right.
Can we furlough her, or do we have to remain on? She's doctor's notes are still coming in because it was quite serious, her operation and everything. So sick notes are still coming in, obviously, and we're still paying a statutory at the moment. Can we furlough that person, or is that something that we've just got to continue until the 28 weeks are up, and then we furlough her at that point?
Yeah, this is a great question because the answer is slightly grey at the moment, but let me just explain. So the guidance that has been published all the way through the last few weeks, and especially recently, has confirmed that people who are on short-term sickness and furloughing, and or self-isolating, should not, with an immediate response, be furloughed. So there should be a business reason for that. So there should be what you would expect, a redundant situation or whatever. The guidance says you can furlough long-term sick who are obviously in receipt of SSP. That's what the guidance says. Now, if we then look at the instructions that came from the Treasury earlier in the week, and I'll just show you this. So this is, you've probably seen this. So there, you see paragraph 6.3. Where statutory sick pay is payable or liable to be payable in respect of an employee, whether or not a claim to statutory sick pay is made at the time when the instruction in paragraph 6.1a is given, so that's being furloughed effectively. The period described in paragraph 6.1 being respected employee does not begin until the original SSP has ended. So in common basic terms, that seems to be saying, or is saying, that furlough or the instruction to furlough cannot take effect until the original SSP period has ended. Now that is in direct conflict with the guidance. If I was going to take one of the pieces of information we've got, one of the documents, I'd take that because it's an instruction from the Treasury and will ultimately end up in legislation. So I would probably err on the side of caution at this moment in time and go with that, albeit that is in conflict with the guidance, which does say, expressly says, you can furlough people who are on long-term sick. So listen, there's lots of things in that instruction which contradict the guidance. I would rather go with instructions which basically those instructions from the Treasury are the rules of the scheme. So they are the rules of the scheme. They may be altered, they may be changed, but at the moment they are the rules of the scheme, which will come to legislation. And as lawyers, if we are interpreting the law, we're looking at legislation, so we've got to go with that.
Yeah.
Now, an example of where the guidance is just ignored completely is around public sector staff. This is just an example of where there's a contradiction. So the guidance has specifically, consistently referred to public sector organisations not using furlough because they've already got public funds. Yeah, in the instruction from the Treasury, that is completely silent on that point. So you've got to start asking yourselves the question, how relevant is the guidance? How enforceable is the guidance? And how correct is it actually in terms of how the rules would apply going forward? So I'm sorry I can't be any more clearer than that, but
okay. It's just making sure they do the right thing, because she isn't fit enough to come back to work at all, and she probably won't be for the foreseeable future. And the doctor's still signing her off. Do you know what I mean? So it's all right furloughing somebody, isn't it? But we've got to do it right. So
yeah. I mean, I would, these things are probably going to be, as HMRC has said, there's going to be questions to be asked, and they've given the various forums you can ask the questions. So it's probably things like that we're going to have to clarify. But as of today, bearing in mind we've got that piece of what is effective legislation or the rules, I would go with that at the moment. And then see if anything develops in the next week or two, as these things have tended to do. And then you can take a view at that point.
I have got to her saying that she'll be continuing on a sick, like test for the next 28 weeks. However, if anything changed due to the government guidance, I would let her know.
Yeah. Okay. Well, I think that's the thing. Keep an eye on that, and hopefully we'll get some clarification on those rules, and hopefully it will be in legislation, like in the next couple of weeks anyway. So it will be in black and white. So there will be, we will know exactly what the rules are at that point. Yeah.
Thank you, Chris. Thank you.
Okay. Thank you very much. Thank you. Kieran?
Yeah, we have Jane Carroll. Question came yesterday. So, Jane.
Hiya. Hi.
Hi, Jane.
Hiya. Okay, so my question was around collective consultation and whether we can start that whilst people are on furlough. Might have just been picked this morning on BBC News on this one.
Oh right, okay. Well, I didn't see that. So
sorry, but I'd like to hear your response.
I don't see any reason why collective consultation cannot be carried out during furlough. And I know some people take a view that that will qualify as work, but I don't think it's generating revenue. I don't think it's providing a service as the guidance sets out. So the guidance itself anticipates that employers will make redundancies during furlough leave and actually allows it. So I don't see that collective consultation would be prevented during that period. The difficulty will be actually doing it, I guess. The difficulty will be actually, from a practical point of view, actually carrying out that exercise with all the bells and whistles and obligations that comes with.
Yeah.
Is that what the BBC said?
Yeah, basically. Yeah, essentially. So I have my question and it was answered this morning.
Yeah, I mean, I think the employment rights continue. You can discipline people on furlough. You can definitely make redundancies on furlough because that's within the guidance. So by definition, companies that need to look ahead, I mean, as companies are now doing, obviously, to the end, is furlough going to be extended? Is it not? The government are going to have to, in some ways, the government are going to have to be thinking about organisations taking these steps because furlough is not going to carry on forever.
Yeah, no, it's brilliant. Thank you for that.
All right, Jane, thank you. Cheers. All the best.
Okay, we have next is Steve. I'll just unmute him now.
Hi, Steve. Hi, Steve.
Hi, yeah. Got a question. I'm under furlough. I'm employed by a larger company as a head brewer. And recently we had a reissue of our furlough letter. And in that, they made plain that they would not be allowing us to accrue holidays during our furlough period. Now, that seems contrary to every bit of guidance I can find. If you're sick, you still accrue holidays. If you're a pregnancy leave, you can still accrue holidays. And I don't find anything in anywhere that says they can actually do that. They refer to advice they got from a trade body, the UK hospitality body, and they said they were acting on that. I've registered my displeasure at that, but that's all I've done up to now. I just wanted to know what you guys thought.
Yeah, well, I mean, the advice is wrong. If the advice they've been given that holidays don't accrue, then that holidays accrue. You can't contract out of statutory holidays. It's important. It's a statutory right. Holidays in the working time regulations accrue, as you say, through leave, irrespective of what leave that is. So yeah, you can't contract out statutory holidays. So you are correct. Yeah.
So how would I proceed with this? Because I've sent a letter to our MD saying I don't think this is right. They just sent me a replied email saying we're going to carry on with this because this is under the advice of our trade body. I don't know where I stand. I mean, if this furlough carries on any much longer, I could lose up to 25-30% of my holiday accrual. It seems unfair, particularly as the government has said we can actually roll holidays forward for the next 2 years. So
you can't. I mean, yeah. I mean, you because you can't contract out of statutory holidays, you can't contract out of statutory holidays. So even if you signed a document saying that you agreed to it, it wouldn't have any effect.
Okay. So I guess I'll just wait and see what happens.
I think it's a question of just making your point, and I suppose make the point. If they don't accept it, then even if you sign the document, I would probably ensure that your objection to it is
noted,
is clear, and then you'll be protected going forwards in any event because of the rules around accrual of holiday.
Okay. Thanks very much.
Okay, thanks, Steve. Cheers. All the best.
Thank you.
Thank you. Next question here.
We have Lindsay Holt.
Oh, hi, Lindsay.
Hello there.
Hello.
Right, I've got 2 questions, but I'll make them very brief. The first one is regarding calculating the 80% of average wages based on their gross. With our employees, they do have a gross pay advice, which we generate, but we have internal expenses which we deduct from that before we send to payroll. For example, loan repayments or license repayments. We offer the facility for our staff members. We fund their license and then we take it back out of their wages. So in terms of calculating the 80%, would that be prior to internal deductions or after?
Are the deductions then for benefits then? They're effectively for staff benefits, are they, the deductions you're making?
Yeah, I mean, the examples have given loan repayments. So we did previously offer the facility to have an advance on wages, which was taken back over an agreed period off their gross. And the same with payment for the SIA license. We offer that facility as well.
Yeah,
so,
I would say it's after then.
After.
I would say it's after because it shouldn't include any non-monetary benefits. So
Right.
I would say that's after, yeah.
That's good. That's what I've done. That's excellent. I'm glad I don't have to recalculate. And then the other one was just off the back of the previous gentleman's question about holiday accrual during furlough. So you may or may not be aware, but controversially, currently, because the majority of our team are on 0-hour contracts with variable shifts on a daily, weekly basis, we do run rolled up holiday pay, and we do understand the implications of that, and we're in discussions on a regular basis about it. However, in terms of again accruing holiday entitlement, because we pay rolled up holiday pay, I'm just trying to get my head around that, because the 80% gross would include rolled up holiday pay. Does that mean that is boxed off as such?
Yeah, I had this question last week. I think it is, to be honest. I think your holiday pay is rightly or wrongly rolled up into the salary. So you just continue to do that as you've done it. The calculation would apply as per as per the instructions now, and that's fine. I can't see that there's anything else you need to do. I mean, the question I got last week was around variable hours and accrual of holiday pay and that, and how does that proceed within furlough, which is another question. But again, I'd probably just go back on average over 12 months for that. But I think for you guys, I think you just continue to do as you're doing, really.
Yeah.
The accrual will continue by virtue of the salary you always pay, or the wages you always pay. And
Yeah.
I don't think there'll be a problem. I don't think there'll be a problem there.
Yeah.
I'm sure there's certainly nothing you need to do now, I don't think, anyway, because yeah, I mean, they will be paid, and the calculation is going to be the same. They're getting, I suppose, they're getting 80% of that. So
yeah, they're getting 80% of their average, which includes the rolled up holiday pay. So
exactly.
Exactly. Yeah.
Okay. Yeah, I mean, the principle is more around the rolled up holiday pay, isn't it, than anything else?
Yeah.
There you go.
Thank you. Thanks very much.
Okay, thanks, Lizzie. Cheers. All the best. Okay, Kieran, next question, please.
We got Heather Dixon.
Hi, Heather.
Hi, thank you. I've got two questions, both of them quite short. One of them goes back to one of the earlier questions and is a point of minute clarification. We were talking about the change in the employee start dates, 19th of March, 28th of February, etc. We have a staff member who began with us on the 4th of March. Our RTI submission was made after the 19th of March. Does she qualify for furloughing or not? Because I've read contradictory advice around that.
So she was employed on did you say the 4th of March?
She physically started in our offices on the 4th of March, but we don't pay until the back end of the month, and there are no RTI submissions made until we pass over the information to the payroll agent.
She won't qualify then for furlough.
Okay, that's fine.
No.
That's the basis on which I'm working, but I just wanted to be clear.
Yeah.
The second question I've got is that we've been talking about the fact that furlough must be evidenced in writing. We held one-to-one meetings with all our staff. We sent letters to them. We've communicated widely and continue to communicate widely with them. What we haven't done is ask them to sign anything. Should we, and do we need to do something about that?
I would, because it does now refer to a written agreement. So I think I would. I think it probably can be done on email. But should the audit come in the future, then it's better to have one document, I think, to prove that. I certainly would say there's nothing in any of the guidance or the instructions which prevents predating the agreement either. So as long as there is a written agreement.
Yeah, I mean, we haven't had difficult conversations. People have actually been very reasonable.
More than happy to do it. Yeah.
But it just strikes me that it is something that we've not done, and I wondered if it was something.
Yeah, I think it's just an administrative issue, isn't it? In terms of personnel file, furlough document, audit comes in 12 months' time. Bang.
Yeah, well, I used to be an auditor, so maybe that's where the question comes from.
well, we all know that fully well. Yeah, absolutely.
Yeah. Okay, thank you.
Okay, thanks very much. Cheers. All the best. Next question, Kieran.
Yeah, we have James Podwin.
Yes, hi Chris.
Hi James.
Hi, you touched on the sort of end of the furlough period earlier on, and it does list in that guidance, the one that you had on the screen, that it may be extended if necessary. So a couple of things on this, because I can't find any details about it, but it's to help us plan a little bit. The first one is kind of, when would you expect that kind of announcement to be made, whether it was extended or not?
Oh, I would guess it's going to be announced along with the next announcement around the lockdown. So my best guess is early mid-May, maybe 11th, 10th or May, something like that. I can't see they're going to leave it any longer than that, because employees need to know what the position is going to be. And I would have thought that when the government are looking at their plans going forwards, the biggest issue for them, along with the health of the nation, the biggest issue is the economy and what they can afford to pay out, bearing in mind that furlough is obviously costing them quite a bit of money. So I would guess it's going to tie into that mid-May period. That's what I would guess. It's a good question. It's a good question, because obviously, as I said before, everyone is now looking at what is going to happen next when the downturn is here.
Right. So what you think reasonably it's going to be? They're going to give people 2 weeks planning. So the second part to it is I'm going to call it professional opinion. I might ask you to grab that crystal ball on that beach behind you. It's like
it's been out a few times in the last couple of weeks. So,
yeah, I'm sure. I mean, what is your opinion about whether it would be extended or not? Obviously, I know we won't hold you to it, but I'm just keen to know what, call it the word on the street, or where it sort of sits with you.
I think it will be extended. I cannot see where we are at this point in time. The fact the scheme has really only hasn't really got off the ground yet in terms of the administration of it. It was deemed initially to be for a minimum of 3 months. This isn't going to go away quickly by the looks of it. So I think it will be extended. And we've heard lots of different noises from various different sources. You know, it's going to be extended, but it's going to be on a reduced pay. So it's going to be on 60% or 65% as opposed to 80%. There's been all sorts of talk around that. But my impression is that, and I think we all agree who are dealing with all this, that it will be extended. Because there's going to be a cataclysmic effect on business if it isn't, because there's going to be a large cliff face which is facing a lot of businesses.
Okay, thanks, Chris. That's really helpful.
Okay, thank you very much. Cheers. Okay, Kieran, next one, please.
We have Jen Lancaster.
Hi, sorry.
Oh, hi, Jen. Hi, Jen.
Yeah, my question is, I've had an email from an employee who's contracted to 20 hours per week, and she's been on that contract for the past 5-6 years. However, she does occasionally work 10 hours or so overtime a week in the store. So now she's asking if her 80% payment will be off her overall average hours for the past year rather than just 80% off a contracted salary.
Certainly not if it's occasional. No, definitely not if it's occasional. So it's got to be, it's got to be overtime which is fairly consistent, or is compulsory, or is obligatory, or that's what the rules are telling us. So no, if it's occasional, then certainly not.
Okay, perfect. Thank you.
Okay, thanks, Jen.
Thank you.
Okay, and we have a last question at the moment. Somebody, it's Wendy Barnes.
Oh, hi, Wendy.
Hi, Chris. My question is with regards to the furlough leave. Obviously, we've had the discussions with people. Does it commence from the date you have the discussion, or the date you get the furlough leave agreement signed?
It's when the furlough, the employee is told to leave work and has been provided with no work. So the instruction from the Treasury defined furlough, which I think I just showed previously before, but they talk about, just let me find the relevant sections on yeah, so an employee is furloughed if the employee has been instructed by the employer to cease all work in relation to their employment. The period for which the employee has ceased or will have ceased all work is 21 calendar days or more, and the instruction is given by reason of circumstances arising as a result of coronavirus or coronavirus disease. So that means that if you have employees who have been laid off as of 2nd of March, for example, then furlough could effectively start from then, or if employees were in that scenario we talked about before were made redundant and then rehired, they could start from the day that they left or effectively had no work. So it starts from the day that instruction has been given, not when the agreement is signed.
Okay, that's great, because I was just a bit confused with the fact sheet that was put out on the 5th of April. With the comment around the employee can claim from the date the employee was actually furloughed, not the date of the communication. So I just wanted to be clear on whether or not we needed the signed agreement to match up with that.
Yeah, well, you need a signed agreement, as we now know, because that's
Yeah.
what the guidance now says. But that doesn't need to predate the period of furlough.
Right.
And that there could be scenarios where somebody has been sat at home on layoff for weeks, and therefore, if they've been instructed to cease all work, and it's because of the coronavirus, then you could go back to them and say, right, we've actually now been told we can furlough you, so here's the agreement.
Okay.
And it's predated. Yeah.
That's great.
Yeah, yeah. Okay, Wendy, no worries.
All right. Thank you very much.
Thank you.
Goodbye.
Do we have any other questions here in?
Yes, we have 2 more. Mark Meth. I'm just looking him now. Give me 2 seconds. Yeah, Mark, good to go.
Yes, good morning, Chris.
Oh, good morning, Mark.
My query relates to you touched on the whether or not the furlough period is going to be extended beyond the end of May. We'll just have to wait and see about that. But we've got guys who have been on furlough for quite some time, and then we've also got guys who I've got on a rotation of 3-week furlough periods, giving them an option to carry on working and trying to keep everything fair. With the agreement running out as it stands at the moment at the end of May, does that mean that nobody can be furloughed after the 10th of May, which is the minimum 3-week period leading up to the end of May?
Yeah, it's a good point. Currently, if you're doing that rotation basis, and because there's going to be, as you say, there's going to be that 3-week minimum, then that would be correct. It would. Yeah, it would, as it stands. The 3-week rotation will not be able to apply if you get past that period. So yeah, as it stands, that is correct. Which is another reason why you would expect the government to step in at some point. Yeah.
Let's hope so.
Let's hope so.
Thanks very much.
So. Okay, thanks, Mark.
Okay, and we have Michael. Just unmute him now. Go ahead, Michael.
Hi, Chris.
Oh, hi, Michael. How you doing?
Yeah, not so bad, are you?
Yeah,
Mike,
good, thank you. Yeah.
Got an employee on furlough leave. They went on the 2nd of April. Yesterday, they contacted me because somebody in their household has got symptoms to tell me that they've been advised by NHS 111 to basically self-isolate for the next 14 days as per the guidelines. But they've also sent an online self-isolation note as well. So my question, do I leave them on, am I okay to just leave them on furlough? Or
yes.
Or do I have to pay them SSP?
No, you can leave them on furlough.
Right, that's great.
Yeah, so there's specific guidance in the guidance, which basically says if I'll read it out. Furloughed employees retain their rights. This means that furloughed employees who become ill must be paid at least statutory sick pay. It's up to employers to decide whether or not to move these employees onto SSP or to keep them on furlough.
The employee's not actually ill; it's somebody in their household who's ill. So
right, fine. No. Well, I mean, the same rules apply in that sense in terms of isolation, but no, you can continue to keep them on furlough. Absolutely.
Right.
Yeah.
Brilliant. Cheers. Thanks. Saves me a lot of hassle.
Yeah. Absolutely.
Cheers. Thank you.
Thank you, Michael. And any more questions from anyone?
We got Freddie Potter.
Hi, Freddie.
How you doing, Chris? You okay?
I'm good. Thank you. I'm good.
Good. It was just a couple of questions, actually. I've just wrote them on the side. It was just to clarify. So we need to get a date signed for when we started the furlough. Is that correct? You
do. So there's got to be a written agreement now between the parties. Again, that doesn't have to be necessarily a document, but a single document. But it has to be. It certainly has to be in writing. Yeah.
And it also says something about them that are allowed to do voluntary work or training. A bit of a grey area. What have you got any clarification on this? Is it, are they allowed to log on to certain things that we pay for and contracted to, and they're doing
yeah. So Yeah, so they can do volunteering on furlough. They can do training on furlough. If training is performed on, or is carried out on furlough, whether that's e-learning or, well, yeah, generally will be e-learning. They can do that. That isn't classified as working, but they must. The guidance confirms they must be paid the national minimum wage for that training as well. So it's likely that that'll be covered in any event. But if there's a significant amount of training being carried out, then we need to make sure we're paying the national minimum wage.
Okay, and is that just training, or can they be doing, you know, stuff on LinkedIn? You know, what will they be? I'm just trying to think of what they'll be like. If for example, we're paying.
Yeah. I mean, they can't provide. They can't provide services and they can't generate revenue. So, you know, somebody on. I mean, this has been a common question. If somebody is on LinkedIn and they're on the personal profile, then I wouldn't say that's work providing services or generating revenue. It's not. It's their own. They're doing what they want to do on social media. So it's just a question of degree, again, which I guess is going to change with each scenario. But yeah, I mean, the concern I think for a lot of organisations is that employees will still have access to their email account and will be checking their emails and maybe even forwarding emails or responding. And that then you start to get into is there, you know, are there services being provided at that point by the individual? And I guess there could be a good argument to say that yes, there are. Right. So it's going to be a question of degree, really, in terms of giving example, you know, kind of sort of looking at the particular example. But a lot of organisations have just said we are not going to take the risk because we know that HMRC are going to be coming after. Well, not coming after, but auditing organisations after this. They've said they're going to be doing it. And the easiest thing for them to check is electronic accounts and electronic information. So they might just do a sample audit of email accounts. And if it transpires that one person has sent an email on the 10th of April, they may very well say, well, that person doesn't qualify.
Just lastly, on the furlough side, is there a minimum term that we'd have to keep someone? I'm not saying that we're going to be doing that, but you know, is there a minimum term that companies have to keep employees?
Yeah, 3 weeks.
Okay.
So they're going on furlough 3 weeks. Yeah.
Okay. Thanks very much, Chris.
Okay. Thanks, Freddie.